How I negotiate a data processing addendum, DPA, for my vendor clients. If you're a software vendor, SaaS, on-premises, or somewhere in between, you have probably encountered a data processing addendum from a customer. Maybe it came attached to a service agreement or bundled with security terms. Whatever it was called, your customer sent it, and now someone has to deal with it. For most of my clients, that is me. Since GDPR went into effect in 2018, I've spent thousands of hours negotiating these agreements. In this video, I'll walk you through how I think about DPAs and what I actually negotiate. This is the inside view of how I approach these agreements for the vendor clients I represent. But before we get to the negotiating, let's make sure we're speaking the same language. A data processing addendum, or DPA, goes by many names, but in essence, it's a legally binding contract governing how a vendor handles personal data. It typically shows up as an addendum to your main service agreement, though I've also seen it structured as a standalone data privacy agreement. It can also be combined with security terms or embedded directly in the master agreement. The label matters less than you think. What matters is what the terms say. At its core, a DPA allocates responsibilities between the controller and the processor. The controller is the customer who owns the data and decides what to do with it. The processor is the vendor who handles that personal data on their behalf. The customer instructs, and the vendor follows those instructions under strict guardrails. DPAs typically cover the purpose of processing, security requirements, and sub-processor management. They also cover data subject rights, breach notification timelines, and deletion obligations. DPAs have been required under GDPR since 2018, but they aren't just for Europe. Virtually every major US state privacy law now requires some form of processor contract. DPAs are now a standard part of vendor onboarding for organizations of all sizes. Now, let me tell you how I actually approach these agreements. Before I get into specific provisions, let me explain my general negotiating philosophy. My goal is always to get through a DPA negotiation efficiently. I focus the energy where it actually matters and accept what is reasonable. I don't redline just to redline. That wastes valuable business momentum. This means we get to the real substantive disagreements much faster. I sort DPA provisions into three distinct buckets for my clients. First, things I regularly negotiate. Second, things I might negotiate. And third, things I don't touch. Let's start with the first bucket, provisions I regularly negotiate. The first area is intellectual property terms embedded in the definitions. I spend a lot of time on confidential information and customer data definitions. These often contain IP terms that interfere with the main service agreement. Customers draft these definitions broadly because they want to capture everything. But overly broad definitions can sweep in vendor technology or vendor data. A standard DPA only needs to define personal data for compliance. Many DPAs mix in broader data governance and IP concepts that require care. Next up is the area where I spend the most time, indemnification. I always ask, is indemnification limited to third-party claims or does it go further? What are the procedures for notice, control of defense, and cooperation? And does the scope stay close to an actual breach of the DPA? Or does the customer try to expand it to any act or omission or simple negligence? That is where I draw a firm line on behalf of my clients. If they go beyond a DPA breach, I push back hard. And I always strike uncapped indemnification every single time. If you want uncapped indemnification, you'll need an incredibly compelling business case. Because otherwise, my answer is going to be a firm no. Related to that is the liability cap. I do not accept uncapped liability on a DPA. I am not interested in a long argument on this. It is a critical risk boundary. The next area is security incidents and breach notification timelines. Customers often request immediate notification, which is operationally impossible. The first 24 hours are consumed with containment and investigation. My standard move is to extend incident notification timelines to 48 hours. This is highly responsive, aligned with standards, and gives the team breathing room. I also push back aggressively on broad incident reimbursement clauses. I limit reimbursement to breach notifications required by law and direct costs. Now let's talk about CCPA and CPRA language for service providers. The regulatory CCPA language is vague and customers often copy it directly. I modify CCPA provisions to make them operationally workable for vendors. Now for security terms. If they are reasonable, I don't spend much time changing them, but I flag anything unusual or disproportionately expensive to implement. I push back on vague phrases like best practices or industry-leading security. And I reject the kitchen sink approach where every possible control is listed. I spend the most technical negotiation time on vulnerability management timelines. Let's move to the second bucket, provisions I might negotiate. First, affiliates. My preference is for the DPA to be strictly between contracting entities. Affiliate structures are usually better handled on the customer's side. If we must include them, I ensure it doesn't expand the vendor's liability. Second, sub-processors. I don't negotiate these heavily if they are reasonable. The key is approval. Does it require affirmative approval or a notice and objection model? Third, government requests. I accept them if they let us comply with law. I always add carve-outs if the law prohibits notice to the customer. Now for the third bucket, what I don't typically negotiate. First, processing restrictions that are reasonably aligned with GDPR standards. If they are consistent with what a processor should do, I accept them. Second, data subject rights. I rarely see controversy here. As long as the response window is reasonable, these provisions are fine. Third, data protection impact assessments. I don't make many changes here. Fourth, standard contractual clauses, or SCCs, which have a standardized form. I only pay attention to the security annex and the liability limits application. DPA negotiation is an area where experience matters a great deal. The provisions that look standard often have massive implications. After thousands of hours, I know where the real risk lives and where it doesn't. If you're a software vendor wanting counsel who knows this space in depth, let's talk. Contact Rob Melton Law today at www.robmelton.com to secure your vendor agreements.